Good day, people of the earth. Have you ever felt like there was something going on and you couldn't put your finger on it? Or that there was some wrongs happening in this world and you didn't quite know how to describe them? Or there was injustice that you just couldn't put into words and you don't know what to do about it? Well, I've thought about these things a lot, so long that I have put them into words. And I believe that I have a plan of action. Wanda Bryant, you've been served. Wanda Bryant, we are also serving you with said criminal complaint for you to file within a court of justice in North Carolina. It is witnessed and has already been sworn to by an officer of the state. It is your sworn duty as a judicial officer of the state of North Carolina to file this criminal complaint against a man named Thomas McAvoy Britton. Here is a second sworn complaint. It is your sworn duty as an officer of North Carolina to file this complaint and create an action on behalf of the people. A declaration testifying to the facts in the complaint. A separate declaration testifying to the facts in the complaint. A third declaration testifying to the facts in the complaint. A fourth declaration testifying to the facts in the complaint. In law, when three forms of evidence provide for the same set of facts, it is a fact upon the record of the court and can only be changed with a trial by jury. Upon movement of an action, all parties to the declaration wish to move before a court of law and testify in open court.
Over the past year, I pray in solitude with patience that the day and time to come when we see justice served and all wrong over the past 6 years turn right, and that I will leave my heirs for to have prosperous life, and that I see all people treated equal, no matter the persons.
Today I'm going to be reading some documents that we sent to actors working in government of North Carolina and their answer and how we will answer them back. For people who do not know what's going on, Henry Ramo and myself got arrested for him just trying to stand up in a court, objecting to the woman who was acting on his behalf as being an attorney. She never put in a notice of appearance in this case. We were both unlawfully arrested, and there was no paperwork at the time of the arrest. If you wish to find out more about that, please go watch the videos that I've made on public notice, lawless authority, and how you know the court has no jurisdiction. Without further delay, I'm going to read the documents that Henry Ramo sent to the appellant court and the judicial officers of the appellant court. These were sent to each individual officer in their individual capacity. He was not seeking aid or assistance from the appellant court. He just wished for the judicial officers to perform their duties and uphold the rights of the people of North Carolina. I'm only going to read what all of the documents said, and throughout this video I'll play Henry Ramo reading the parts that he wrote individually to each of them. Almost 1 year ago, March 26 of 2018, I was lawlessly arrested for contempt of court and let go. I was arrested with no charge, lawlessly, by one Thomas McAvoy Britton, after Thomas's confession of conflict of interest in open court. I contact Mark Martin, but the only answers I got was insult after insult. After said arrest, Jonathan Cross and I made repeated attempts to contact the high clerk, sheriff, and other judicial officers, and were met with silence. I am of the belief public officers can only exercise the right of silence after accusation of a crime or their participation. All documents seek aid and assistance, not make accusations. Even the King of England gave colonists answers to the grievances before the Revolution. On June 29 of 2019, and that was actually a mistake, it was 2018, Mark Martin serves final insult by promotion of Thomas on the same day we seek warrants to arrest Thomas for his unlawful acts. We furnish copies of sworn declarations in hopes you uphold law and our rights, file said documents, and execute the duties and obligations that people entrust with you. Upon documents filed, all sealers of declarations wish to lay testimony on record in open court.
I have fought in a war, was prosperous in life, and have been the best man that I could be for home and country, only to see my successes taken from my heirs by the courts and my ex-wife. My government has protected the wrongdoers and left my heirs and I with debts and hardships. When I fought in the war, it was to preserve the idea that governments are instituted among men to preserve freedom, life, and property. I pray my sacrifices in my life have not been in vain.
I have 3 questions I wish for you to answer. I do not seek or ask for legal advice. I move in law upon answer. God bless, good year, and I look forward to your answers. Now, on the 20th of March, we received this document from the North Carolina Court of Appeals and the clerk who works in that office. It reads, Dear Henry Ramo, your letters have been received by each of the judges of the North Carolina Court of Appeals, and the judges' chambers have routed them to me for a response. You can read this whole thing if you wish. I'm just going to read the really important parts. Right here it says, you have provided copies of sworn declarations in hopes that the named appellant judge in each of your letters uphold law and your rights. You close by listing 3 questions you wish for the judges to answer. You do not seek or ask legal advice. You move in law upon answers. The jurisdiction or legal authority of the Court of Appeals is confined to reviewing judgments or order of the trial courts and does not appear from your letters to the judges of this court that review of such a final judgment or order is being sought at this time. This court and its judges do not provide advisory opinions, and therefore the judges will not be providing answers to your 3 questions. At the same time, they can't give legal advice. The last thing they suggest is all that can be done is consult with an attorney. At least somebody signed it. Daniel M. Horn Jr., Clerk of the North Carolina Court of Appeals. Now I'm going to read Henry Ramo's answer to that document, which the answers have not been sent out yet, but they should have them by the time this video is published. And I will also explain what is going on in this cause or this case or this action. Greetings, Daniel. Thank you for your expedient response, but I feel it has no soul. You state we have provided and then quote the document I present. Secure with documents which contain all elements from this state's idles of law or statutes of law. Then continue to answer. People who act as judicial officers will not uphold his or her statutory oath to said office, to be faithful and impartial, or said officers do not understand or have the ability to discharge duties. I leave you to decide why said officers do not uphold law and rights of the people. So to break it down in English, this comes from Chapter 11, Subsection 11 of the North Carolina General Statutes, which is generally what they use to tell the public what the law is. And I'm not going to read the whole thing again, but I'm just going to point out some really key parts. Obviously, they are swearing to this or affirming, so they're under oath or affirmation, that I will faithfully and impartially discharge all the duties of courts of justice to the best of my ability and understanding, and consistent with the Constitution and laws of the state, so help me God. They are swearing all of this under oath to their God, whatever their God may be. And that's the important thing, is they have a duty and an obligation to uphold the Constitution and the laws of the state. And either they're being impartial by not bringing a warrant of arrest for Thomas McAvoy Britton, or they do not have the ability and understanding of how to do their job correctly, which means basically they are not qualified. I left it up to the clerk to decide which one of those is true, and hopefully he'll get back to me. Now, right here where it's talking about this statutory code, I'm about to break down and interpret, and I'm not an attorney. This is not a legal interpretation. I'm just reading words in English and telling you what I believe that they mean. So let's go look at this statute within the North Carolina Code from the legislature's own website. Again, I'm not going to read this whole section. I'm just going to point out the parts that are important to what we actually did. As you can see, this is the section for warrant for arrest. It talks about when issued. The section that we are concerned with is when citizens initiated, and when the citizens bring probable cause pursuant to this, it must be upon affidavit or oral testimony under oath. When a sworn law enforcement officer is not a part of this process, the official shall not issue a warrant for arrest unless one of the following circumstances exists. At least one disinterested witness. Well, we have two disinterested witnesses. There were two people who wrote out declarations, and they are disinterested witnesses to the crime that they saw. C. The official finds substantial evidence that one or more of the circumstances listed in subdivision 1 of this subchapter, which when we come up to subsection 1, the seriousness of the offense. I believe that kidnapping, detaining people against their will, and forcing them to be slaves to what you are doing to them would constitute a really serious offense. That's just my own interpretation. You can believe whatever you wish to believe. When we come down here to showing of probable cause, a judicial officer may issue a warrant for arrest only when he is supplied with sufficient information supported by oath or affirmation. And I wish to read this to you because I'm going to show you something here in a minute, and the important word in here is the word may. The information must be shown by one or more of the following: affidavit, and that is what our declarations were. And they had 4 declarations from 4 different individuals along with 2 criminal complaints. They had more than what they require for them to issue and show probable cause for an arrest warrant. Who may issue a warrant for arrest valid throughout the state may be issued by, number 2, a judge of the Court of Appeals. This is exactly why we wrote to each judicial officer individually in hopes that one out of the 15 judicial officers might have the common courtesy of fulfilling their duty and obligation and writing and issuing such an arrest warrant for Thomas McAvoy Britton's unlawful and criminal acts. But as you heard in that letter that I just read from their response, they're not going to do that. The reason I asked you to pay attention to the word may and the general statute statute that is active today is because this comes from a case law in 1967. And it says the general statute for North Carolina 1519 provides whenever complaint is made to such magistrate that a criminal offense has been committed, it shall be the duty of such magistrate to examine on oath the complainant and any witnesses who may be produced by him. When this statute was active, it did not say that they may issue a warrant, because they may issue a warrant or they may not. It said that it was their duty to issue a warrant. And in law, a magistrate and a judicial officer has a duty to issue a warrant when members of the public go before him or her and swear that a crime has been committed. And this is just one of the ways that they are slowly taking away the rights of the people. This comes from the legislature's website. It's chapter 15 on the criminal code and the criminal procedure. And as you can see, the subsection that I just read to you from the case law was repealed in 1973. So before 1973, had we conducted these actions, they would have had a duty to write out and sign the arrest warrant for the public. Now, because of the legislature, it says that it's kind of just up to their discretion. They can write it if they want. They don't have to. And just think about that. If violent crimes happen to you, you might not get any justice if the government doesn't feel like it that day. And why are they issuing all these arrest warrants for supposed offenses, for supposed crimes? And they're not issuing arrest warrants for real crimes. Instances when a real man who knows better kidnaps an 87-year-old Korean War veteran and a 35-year-old man who's just wishing to help him and throws them into a cage. How come they won't issue a warrant for these people? On the order for my contempt charge, it never was returned. The process was never returned to the clerk's office. And here is the statute right here from the North Carolina legislature, where it actually makes it a crime. It's a class 1 misdemeanor to not return the process or making a false return. So they are not obeying their own statutes and procedures. So earlier in this video, I showed you where 18 CR 291, that was my arrest order. This is number 18 CR 290, and the case file number is 18 CR 290, which is one number before my order. And if you come down here to the date that this was issued, it was issued on July 11th of 2018. Shows a really high probability that they just put my paperwork into a case, and that's why they never stamped it, is because it is all made up. Again, the return of service, the date received was July 11th of 2018. The date it was served was 7/13 of 2018. Back to this document, it reads, "To add insult to injury, you finished with consultant attorney, when it was the advice of Boyd Massagee II that had myself, daughter, and son arrested for trespass on my property. I believe Jonathan has spoken to attorneys in private who encourage our actions and affirm that said officers have jurisdiction over attorneys, as attorneys are officers of the court, and attorneys' first duty is to said court. To be clear, questions were not for advisory opinions. Said questions were to understand the beliefs of people who wish to act in government. Since actions are louder than words in law, said officers' answers are clear. Please anticipate lawless judicial officers." Now, along with sending that document to Daniel, the man who was nice enough to answer Henry, this document will go to each judicial officer that refuses to do their duty and obligation to the public, and it's in reference to rights and duties. Greetings. It disappoints me that each of you and all of you do not uphold my rights and perform your duties or wish to settle in private. I fought in the Korean War for the rights of you, your family, and all American people before almost all of you were born. I had one brother, and many friends die for those rights. Since time immemorial, people have rights and officers of government have duties to uphold said rights. It is from government intrusions on these rights and the good people who stop the intrusions that the common law derives. It is my hope that we can still work out this problem together, but for now, I hope you understand why I must inform the public of these actions. I also wish you to understand, even though you forsake my family, I wish you well and will continue to struggle for your rights. Well, Just Conspiracy, what can we do about this? You know, I'm just one individual. I probably can't do anything. I probably can't make any difference in Henry Ramo's life. I mean, come on, the government is big, bad, and powerful, and very intrusive. Well, let me just throw a few ideas out there. There's a lot of people who see the big wrongs, who feel the federal government's overreaching powers in their small towns and their small communities. But honestly, how can we as a society believe that we're gonna fix the really big problems without starting with the really small ones? This injustice is happening to a man in a county court, the first place anybody goes to receive any type of justice or actions for wrongs made against him or his persons, or her or her persons. I'd kind of like to talk about the Constitution of North Carolina and then just give a few suggestions. Article 1, the Declaration of Rights. And again, I'm not going to read everything, I'm just going to point out the parts I believe are very important. The equality and rights of persons. It's self-evident that all persons are created equal, and they all have the same rights. And we all grew up with this belief. This is what they teach us in school. This is how they sell consent of the government to everybody. Section 2. Sovereignty of the people. All political power is vested in and derived from the people. All government of right originates from the people, is founded upon their will only, and is instituted solely for the good of the whole. Section 3. Internal government of the state. The people have the inherent sole and exclusive right of regulating internal government and police thereof, and of altering or abolishing their constitution and form of government whenever it may be necessary to their safety and happiness. This right can only be exercised in pursuance of law, consistently with the Constitution of the United States. And this is the part where a lot of people get tripped up, but it really is not that difficult. And I'm going to explain how. This is a book that gives pretty much a step-by-step direction on how civil government should be implemented and how it should work. It was written by John Locke. The second treatise of government was instrumental in the founding of the United States after it broke away from England. If you go to chapter 18 and 19 of this book, 18 is of tyranny. It's what a tyrannical government looks like, and 19 is of the dissolution of government, and it basically tells you the lawful means of dissolving a government. The chapters before this, 1 through 17, for the most part talk about how to set up a new government and how that government should function and operate. In the Constitution, where it talks of altering or abolishing in pursuance of law, John Locke's Second Treatise of Government is an excellent book to describe to people and the way for people to learn how to do this in a lawful manner. That is what I would suggest for everybody to do, is go and educate yourself about what's going on. What are your rights? Do you have to have an attorney to stand up for your rights? Because it is very, very clear that the appellate court justices of North Carolina believe you do. So let me just read some questions that were sent to Linda McGee, Wanda Bryant, Donna Shroud, Robert Hunter, Chris Dillon, Mark Davis, Richard Dietz, John M. Tyson, Lucy Inman, Valerie Zachary, Philip Berger Jr., Hunter Murphy, John Arrowwood, Toby Hampson, Allegra Collins. Let me just read you some of the questions that we sent to them, and I'm going to give you my interpretation of the answer based upon their actions. Do you believe natural man or woman has lawful rights equal to or higher than an attorney, even if said mankind only knows right and wrong within their hearts? Obviously, the answer to that is no. They don't. They believe you have to have an attorney for them to uphold any of your privileges. And that's why they said to go seek legal counsel. Do you believe judges are gods among men? The answer to that is an astounding yes through their actions, because they will not hold Thomas McAvoy Britton liable, even though they have all of the elements and duty to do so. Do you believe the man and woman are made in the image of the one true sovereign of all things? The answer to that appears to be an astounding no. They do not. Otherwise, they would respect the rights of the people and perform their duties. Another question was, do you believe man and woman are sons and daughters of that one true sovereign? And again, I would have to say the answer would be no through their actions. Do you believe that state statutes or moral law to be the higher authority? And from their actions, I would say that they don't believe either one to be authority over them. They live by their own law and their own rules, because they're not following state statutes or moral law. Do you believe state statutes or the common law of the people to be of higher authority? And again, I would say that they don't believe in either one. They believe themselves to be the highest authority, and they do not have to answer to the people who vote them into office. Do you believe the living voice of a man or a woman is the most powerful thing in a court of law? And I'm just going to go ahead and answer this. It absolutely is. This is the reason why Thomas McAvoy Britton had myself and Henry Ramo drug out of court, was because Henry's voice, what he said on the record of the court, is the most powerful thing in a courtroom. And that's why Thomas McAvoy Britton did not wish for him to speak. I'm going to leave the audience with this thought. If the audience believes that there is something wrong, that we should do something to uphold people's rights, that we should stand for some type of justice in our society, that we should do something on a local level to try and correct these injustices. If they wish to go and educate themselves on the lawful ways of changing government, the first thing I would say is that you should ask yourself, do I wish to have a ruler or a leader? Because that is probably the most important thing to know before you choose and decide to try and go about this action. Thank you for your time. Thank you for listening. Thank you to all of the people who have gone to jcshaman and baba.com and signed up on the emailing list. We really appreciate it, and we will be contacting and sending out emails more regularly at this point in time. We've just been spending the past year putting together a strategy and deciding how we're going to move forward, no matter what the actors of government choose to do. A special shout out and great thanks to all of the people who donate and help support us and keep us going in our actions. We appreciate it very, very much, and without you, it would be impossible for us to do this. I am Just Conspiracy, and I just wish to conspire with other good people of this planet to leave a better world for future generations than the world we all grew up in. Thank you. Allegra Collins, sealed. Toby Hampson, John Arrowwood, signed, sealed, about to be delivered. Hunter Murphy, signed, sealed, about to be delivered. Phil Berger, can't pronounce your last name. Phil, greetings. Look, if you have any problem with the declarations, we'll come in and testify. No problem there. Signed, sealed, about to be delivered, Phil. Valerie Zachary, that rhymes. Lucy Inman, signed, sealed, about to be served. John Tyson, signed, sealed, about to be served. Richard Dietz, signed, sealed, about to be served. Mark Davis, signed, sealed, about to be served. Chris Dillon, signed, sealed, about to be served. Robert Hunter, signed, sealed, about to be served. Donna Stroud, signed, sealed, about to be served. Wanda Bryant, signed, sealed, with a little boo-boo, about to be delivered or served. Chief Justice Linda McGee, signed, sealed, you're about to be served.
I grew up upon this belief that in this nation, actors of the state know equal rights of people is self-evident, that among these sacred rights are freedom, property, and access to the courts of law. These are the ideas that my brothers and I fought and died for the military, and to see my children's inheritance stolen by those called courts of my ex-wife, and who has committed numerous trust law violations, including the unlawful sale of property out from under the rightful heirs.